Yes, please.
From supplementary list, item number 1.
May I please, Your Lordship?
You have a clean writing pad. Clean writing.
5-10 minutes.
Writing pad. Yes, please.
Please, Your Lordship. My first argument is, my Lord.
Yes.
My first argument is, my Lord, this instant case is not a case of change of date of birth at the fake end of the appellant's service, my Lord. This instant case is a case of irregularities.
Yes.
My Lord. Yes, my Lord.
I remember. Yeah.
Yes, my Lord. It's committed by the state respondent. Second argument is, my Lord. Argument is, my Lord.
You have shown us two endorsements.
Yes.
One 1964.
Yes,
And one 1967.
67, my Lord. Yes.
All right.
Oh, yes, my Lord.
And as far as the official record is concerned,
Yes, my Lord.
it was always 1964 in the records.
My Lord.
But you have also shown photocopies of two identity cards and two documents
Yes, my Lord.
where 1967 is recorded.
Yes, my Lord.
Now, who issued those identity cards and when?
My Lord, it is state respondent, my Lord.
When?
My Lord, date is not mentioned in the ID card. The time and again, they have in the first service ID card I have shown, my Lord, in the paper form, and the second ID card, my Lord, before is retiring 2-3 years back, my Lord. And my Lord, in the service book itself, my Lord, there is two date of birth recorded, my Lord. One is the year 1964 in the roll, my Lord, in the service roll, and another is 24th January 1967.
They are saying that it was 1964 all through.
Yes, my Lord.
Officially. Now, who inserted 1967 also?
Yes, my Lord.
According to them, it was slipped in.
Yes, my Lord.
That they do not know.
My Lord, which is why, my Lord, it is the custody, they are the custodian, my Lord. They are the custodian of the service records.
So, this is your case?
Yes, my Lord. I have put two judgments, my Lord, in compilation.
1988.
Yes.
When did you join?
My Lord, on 3/3/1988, my Lord, appointed.
1998.
1988, my Lord.
As
motor mechanic, my Lord. In the office of the Superintendent of Police, William Nagar, North Caro Hills, my Lord.
Superintendent of Police?
In the office of the Superintendent of Police, North Caro Hills, as motor mechanic, my Lord.
Not Garo Hills.
North Caro Hills, my Lord.
Yes.
Yes, my Lord. Thereafter, my Lord, immediately after issuing the appointment, I submitted, my Lord, the school certificate dated 9/3/1988, my Lord. From the school where I studied, my Lord. Class 7 pass, my Lord. School certificate. They have admitted it is on record. The only difficulty is there is no order from the competent authority to recognize the school certificate. It's a long back I have submitted before the state respondent for recording of the actual and correct date of birth in my service record. And
So, in the school certificate, what is the date of birth?
my Lord, my Lord, date of birth is recorded as, my Lord, his age at that date according to the admission register as 12th years, 0 month and 7 days, my Lord. Is the school certificate, my Lord. 12 years, 0 month, 7 years, 7 days, my Lord. That is this, as per the school certificate. My age at that point of time is 21 years, my Lord. At that point of time when I was appointed, my Lord.
So, date of birth would be? What would be the date of birth?
Date of birth is as per school certificate 24 January 1967.
Then how was this date of birth in the school certificate recorded in the service records?
My lord, that state respondent has to answer, my lord, to this query, my lord. I have, as per the instruction, immediately after my appointment, I have submitted. That service record is not in my control, my lord. They are the custodian, my lord. I have never been access to the service records, my lord. And during the long career of my service, the occasion had not arisen, my lord, so that I can peruse the
No,
service.
when you obtained the service or when you applied,
Yes, my
you
lord.
must have entered your date of birth, documents, etc. That is necessary. So where are those documents?
My lord, yes, my lord. My lord, kindly.
It is date of birth will not be recorded after appointment. It is before appointment.
My lord, when I was appointed, that point of time, the school was not issued the certificate because I have passed out, 7 drop out, my lord. When I appointed, the state respondent instructed me to get the school certificate where I have studied for the purpose of recording of the actual and correct date of birth. My lord, kindly have page 45, my lord, in my writ appeal petition, my lord. Page 45. That is biodata. My lord, perhaps the date of birth, my lord, they have recorded 1964 and 24th January 1967, my lord.
Page 48.
Page 45, my lord. Annexure 7, my lord.
When was this submitted?
My lord, this is the service records part, my lord, biodata from the respondent's office, my lord. Kindly have, my lord, number 9, my lord, serial number 9, date of birth, my lord. That is where the mistakes committed, the irregularities committed, my lord.
Number 6, not 9.
9, my lord. Serial number 9. My lord, it is
Page 45.
page 45, my lord. It is number 6, my lord.
Should be 6.
It should be 6, but my lord, 4, 5, then 9, 8, my lord. I know it's a mistake, my lord. It's a date of birth, my lord. It's handwritten.
It should be 6. Then educational qualification should be 7.
Yes, my
and
lord.
then 8, 9, 10, 11, it's all right.
Yes, my lord, my lord. It's in handwritten, 1964, then 24th January, 1967. So if 1964 is my correct, where is the month and day, my lord? Day and month. It is in bracket, my lord. Somebody has put in circle, my lord. And another aspect, my lord, in GPF statement also, my lord, it's a government record. In GPF statement, the actual and correct date of birth they have recorded, my lord, in GPF statement.
Where is the GPF statement?
My lord, yes, my lord. My lord, at page 52, my lord. Page 52, annexure 11, my lord. My lord, in the left side, top, my lord, or the top of the left side, my lord. Date of birth, my lord. (24/01/1967), my lord. That is my actual and correct date of birth. My lord, it is their record, my lord.
This is GPF.
Yes, my lord, GPF statement, my lord, from Office of the Principal Accountant General, bracket ANE, Meghalaya, my lord. My lord, come to page 74, my lord. The Superintendent of Police had written to Assistant Inspector General of Police. It's a letter, my lord. Page 74, my lord. The mistakes, irregularities they have admitted, my lord, in this letter, my lord. May I read, my lord? Date of birth in respect of Shri Shohidur Rahman Mullah, mechanic, so-and-so. With reference to the subject cited above, I am to inform you that on thorough scrutiny of the service book of Shri Shohidur Rahman Mullah, mechanic, FNES, Mendipatar, the below mentioned anomalies have been found and the same is being placed in front of you for favor of information and advice. That on thorough scrutiny of the service sheets and other connected documents of Shri Shohidur Rahman Mullah, mechanic, it is found that the date of birth of the Shohidur Rahman Mullah was entered as 1964 in his service book volume 1 during the enlistment in service of Meghalaya Home Police Department on 1/3/1988. Further, his date of birth in the verification roll submitted during the appointment into the service is also entered as 1964. Then in the same year, this is important, in the same year, that is 1988, Shri Shohidur Rahman Mullah submitted one school certificate, date of issue 9/3/1988 from so-and-so school, Gwalpara, Assam, to Police Reserve Office, East Garo Hills, and as per the records of this school, his date of birth is 24th January that would be 67, my lord. The same is found to have been entered in his service sheet volume 1 as 1964, then 24th January 1967, mentioning both the years as 1964 and 24th January 1967. However, no official order to the competent authority could be seen in his service records, service books for change his date of birth from 1964 to 24th January 1967. Furthermore, there is no other supporting document such as birth certificate, etc., to prove his date of birth. It is also noticed that in the records of O/O, the Principal Account General, the Shillong Statement of Account, the date of birth of Shri Shohidur Rahman Mullah is entered as 24th January 1967. My lord, they have admitted, my lord, there's a mistake. And the same year, I pleaded also the same thing, my lord. When I was appointed, I was instructed to file the service school certificate. I have submitted, my lord. I would like to submit two judgment, my lord, compilation, my lord. Judgment. Two copies. These are the four judgments. Judgment. mark করার mark করার order দিয়েছে sorry this one mark করার my lord, one is my lord 2022 volume 6 SCC 211 Shankarlal versus Hindustan Copper Limited and others, my lord. My lord, relied on para 23, 27, 29 and 30, my lord. And one is Bombay High Court judgment, my lord, with regard to the school certificate.
23,
My lord, 23, 27, 29 and 30, my lord. In my compilation,
there is no 39.
my lord's 29, my lord. 29.
23, 27, 29.
29 and 30, my lord. 30, my lord. And another judgment, my lord.
Well, let us read this.
Yes, ma'am.
Yes.
Yes, my lord. My another judgment, my lord, is from Bombay High Court, my lord. 2014 SCC online Bombay 2243, my lord. I relied on para 14 of the judgment, my lord. May I read, my lord? Para 14 and para 15, my lord. Two para I am relying. The compensation.
Para 14 and
15, my lord.
That's all?
Yes, my lord, that's my answer.
Yes.
May it please your lordship. Lordship, if I may I read the operational part of the judgment by the learned single bench, lordship? Lordship, at page 120 of the appeal, my lord, at paragraph 5. I'll read, my lord.
Yes.
Lordship, having heard the learned counsels for the parties, the case of the petitioner can be seen to be grounded only on the reason given by him that he was unaware about his year of birth being shown as 1964 instead of 1967 throughout his service career, and that he came to learn about this discrepancy only after being served notice with the notice of superannuation dated 10/5/2022. To appreciate his contention, the records and materials as produced have been perused thoroughly. What strikes this court in the first instance is that there are two entries of the year of birth in the service record, that is 1964, and subsequently 1967. To the naked eye, it can be easily discerned that 24/1/1967 was entered after the service record had recorded 1964 as the year of birth. And further, there is no endorsement showing as to how or when this correction was allowed. Apart from the submissions of the petitioner that the same was corrected on the basis of the school certificate, no material is present to show as to when the school certificate was supplied or any order allowing such correction by the respondents. Another aspect that cannot escape the attention of this court is the fact that as per the verification rule, at the time of entry of service, the same clearly shows that the year of birth as 1964, which is acknowledged by the petitioner, who has also appended his signature, and the same endorsed by the then respondent number 5. Lordship. With that, my lord, if I may take your lordship to the biodata, which has been pleaded by my friend at page 45, annexure 7 of the appeal, lordship. The first submission I would like to place before this honorable court is the order of his appointment, lordship. The date is very clear. It's 3/3/1988, lordship. This is at page 36, annexure 1.
Yes.
3/3/88, lordship. And what has been relied upon by the appellant, my lord, is is at page 38, lordship. This certificate is dated 9/3/88, my lord. This is a good 6 days after he had joined service, lordship. My lord, at the point of joining service, the biodata and the verification role would have been filled up prior to his having submitted this certificate, lordship. Lordship, the biodata has been noted as 1964. Interestingly, a bracket has been put over there, my lord, and it has been filled up with 1967. What my friend has avoided to place before this honorable court, though it is on record, lordship, is the verification role at page 70, my lord. Lordships have it, my lord.
Yes.
If I may read, Lordship, this is the verification rule, Lordship. Name and cast, the name of the appellant is their Lordship, Mohammed Soidur Rahman. The date of birth, Lordship, 1964. And in this very verification rule, Lordship, the thumbprint of the appellant has been appended thereto, Lordship. And this has what has been brought out in the judgment by the learned single judge, my lord.
Where is the verification rule taken?
Lordship, the verification rule is also 388, my lord. 388, Lordship. Surprisingly, there's no change here, Lordship. There's only 1964. That's my first point of contention with regard to the age of the appellant, Lordship. And it is within his knowledge because his thumbprint has been appended thereto, Lordship. My lord, this is public service, Lordship. In case there had been any call from the appointing authorities for a school certificate, the appellant has not been able to furnish any order by the appointing authority directing them to file or to produce a school certificate. 1964 is the accepted year of birth, Lordship. And my lord, the service rules are very clear that if the month and the date is not known to the employee, 1st of July is taken to be the date of any employee who's unaware of the birth or the date of birth. The birth month or the date of birth, Lordship. So this has been noted in the order and the judgment passed by the learned single judge, Lordship, because if there had been any change in the biodata, that change would have followed even in the verification rule. But this was not done so, Lordship. This argument is also supported by the judgment passed by the learned single judge, Lordship. Now, my lord, my second point of contention is,
Yes.
Lordship, along with the compilation of judgments, my lord, I would like to place before this honorable court. And before I go on to my second point of contention, my lord, I would like to again stress on the fact that this difference, wherein in the biodata there was a correction or change unknown to the authorities or known to authorities, my lord, that same, the discrepancy therein with the verification rule has never been explained by the appellant, lordship. Secondly, my lord, as per the...
He retired on 31st December 2022.
My lord, 30th of June 2022. 30th, no, 31st? 30th of June, lordship. Because the date of birth and the month was never given. So as per the service rules, lordship, is the date of birth, if not given by the employee, it's taken to be 1st of July, my lord. That is as per the rules, lordship.
Even if it is given, it is taken in that way. At least in West Bengal,
Lordship.
If your date of birth is 10 July,
Lordship.
you will retire on 31st July.
Lordship. 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 Now I come to the point of delays and lashness, my lord. Now, my lord.
He retired, and if 67 is the date of birth, he would retire 31st December 2024.
25, my lord.
No, 24.
24, lordship. If
25, my lord, in the next year approaching, my lord.
If it is taken as 67.
Yes, my lord. 67, 1967.
there'll be a difference of 3 years, my lord, because our contention is 64, lordship. And the contention has proven...
He is already retired. On
He's
30th.
retired, lordship.
Release from service, my lord. Yes, sir.
31st December 25.
My lord, no, my lord. Since it is January, my lord, so in the month of January he will retire, my lord.
31st January 25.
Yes, my lord.
My lord.
Yes.
Now, I move on to my second point of contention, Lordship, that is the delays and lashes involved over there. Lordship, the appellant had come before the authorities after a gap of 34 years, Lordship.
After a gap of?
34 years of service, Lordship. And this is also just 3 days prior to his retirement, my lord. Now, my lord, what is very interesting in this matter is that if he had at all been at a disadvantage of knowing a fact to him that his year of birth is 1967, Lordship, on record, he had accepted all the emoluments of pension and retirement at that point of time, Lordship. This was without any objection, my lord. And the same can be supported by the respondent number, right? 6, my lord. Now, my lord, with regard to the delays, Lordship, this application was made after a lapse of 34 years, Lordship. And I would like to bring to the notice of this Honorable Court, in State of Madhya Pradesh versus Premlal Shrivas, 2011-9, SEC 664, Lordship, at paragraph 8, my lord. That is the first judgment, my lord.
Yes.
If I may read, my lord. It needs to be emphasized that in matters involving correction of date of birth of a government servant, particularly on the eve of his superannuation or at the fact end of his career, the court or the tribunal has to be circumspect, cautious and careful while issuing direction for correction of date of birth recorded in the service book at the time of entry into any government service. Unless the court or the tribunal is fully satisfied on the basis of the irrefutable proof relating to his date of birth, that such a claim is made in accordance with the procedure prescribed or as per the consistent procedure adopted by the department concerned, as the case may be, and a real injustice has been caused to the person concerned, the court or the tribunal should look into the issue for correction of the service book. Time and again, this court has expressed the view that if a government servant makes a request for correction of the recorded date of birth after lapse of a long period of time of his induction into the service, particularly beyond the time fixed by his employer, he cannot claim as a matter of right the correction of his date of birth, even if he has good evidence to establish that the recorded date of birth is clearly erroneous. No court or the tribunal can come to the aid of those who sleep over their rights. And Lordship, just from the records, my lord, that has also proved to be a discrepancy with regard to 64 and 67, Lordship. The second case law, my lord, is 2020, volume 3, SEC, page 411, Bharat Coking Coal Limited versus Shyam Kishore Singh. At paragraph 9, my lord, this court has consistently held that the request for change of birth in the service books at the fact end of service is not sustainable. This court has considered a number of judgments on this and observed that the grievance as to the date of birth in the service record should not be permitted at the fact end of the career, of the service career. Relief has been denied to the government employee, accordingly on this ground, after he had sought correction of service after nearly 30 years. At paragraph 10, my lord, even if there is good evidence to establish that the recorded date of birth is erroneous, the correction cannot be claimed as a matter of right. Now, my lord, as I have pointed out in my first line of submission, my lord, that there has been no call, no direction from the authorities concerned for any school certificate therein. My lord, no application for date of birth can be made without the relevant provisions or regulations applicable, Lordship. Changing the appellant's date of birth from 64 to 67 is in contravention with the rules of, as laid down in the note appended to SR 8 and of FR and SR rules 1984, Lordship, which is reproduced here after, my lord, if I may read, at page 4 of my compilation. No alteration in the date of birth of a government servant should be allowed, except in very rare cases where a manifest mistake has been made. Such mistake should be rectified at the earliest opportunity in the course of periodical re-attestation of the entries in the first page of service book. In no case, requests for change in the date of birth of a government servant made on a date within 3 years of the date of his actual superannuation should be entertained. Lordship. The Honorable Supreme Court in the case of Karnataka Rural Infrastructure Development Limited versus TP Nataraja 2021-12 SEC 27, paragraph 11, Lordship, held that considering the aforesaid decisions of this court, the law on change of date of birth can be summarized as under. Application for change of birth can only be as per the relevant provisions, regulations applicable. 2, even if there is cogent evidence, the same cannot be claimed as a matter of right. And 3, application can be rejected on the ground of delay and laches. Also, more importantly, when it is made at the fag end of service and oblique, or when the employee is about to retire on attaining the age of superannuation. Lordship, in addition, my lord, the application for the correction of date of birth should not be dealt with keeping in view only the public servant concern. My lord, the appellant had retired on 30th of June 2022. No objection. GPF, pensionary benefits received, lordship. And moreover, he had signed the pension papers, lordship. Now, as an afterthought, lordship, he approached this honorable court for reasons best known to him. The lordship in Secretary and Commissioner, Home Department versus R. Kiru Bakaran, 1994 Supplementary, Volume 1, SEC 155, at paragraph 7, lordship. An application for correction of the date of birth should not be dealt with by the tribunal or the High Court, keeping in view only the public servant concern. It need not be pointed out that any such direction for correction of the date of birth of the public servant concern has a chain reaction, inasmuch as others waiting for years below him for their respective promotions are affected in this process. Some are likely to suffer irreparable injury, inasmuch as because of the correction of the date of birth, the officer concerned continues in service, in some cases for years, within which many officers who are below him in seniority waiting for the promotion may lose on the promotion forever. My lord, this is the compilation of cases on behalf of the state lordship. My lord, if I may take your lordship to the compilation of cases placed by my friend before this honorable court lordship.
You have cited 4 cases.
Right, no, 4, my lord. Lordship, I've cited.
2011-9,
My lord?
670,
Lordship.
2020,
Lordship.
3.
Lordship. 2021, my lord. 1994, my lord.
Then 2021, 12, right?
Lordship.
27.
Page 27, my lord.
And the last one, 1994.
Supplementary lordship. Volume 1, SEC 155.
Okay.
My lord. This is the compilation on behalf of...
Give us the paragraph numbers of 2011-9 SCG.
My lord. The paragraphs quoted, referred to us, my lord, referred by us is at paragraph 8, lordship.
8.
Lordship.
And 2023 SCC 411, paragraph.
2023, my lord. Lordship 2021, my lord. Not 23, lordship. Lordship 2011 is the first case cited by us. The second case is 2020, volume 3, my lord.
Yes, that is which
my lord.
paragraph?
Paragraphs 9 and 10, lordship.
And then 2021.
2021, my lord. It is at paragraph 11.
And 1994.
Paragraph 7, my lord.
Okay.
Lordship. My lord, in furtherance of the same, my lord, my friend has placed 2 judgments before this honorable court, lordship. And lordship, if I may take your lordship to the paragraph referred to by my friend in 2022, volume 6, SCC, lordship. The first case relied upon by my friend, 2022, volume 6, SEC, Lordship. If I may read the paragraph relied upon by my friend, Lordship, at paragraph 27, we find the action of the employer lacking authority of law in two counts. The decision not to follow the service book records was taken without giving an opportunity of hearing to the appellant. My lord, over here, we place the same argument at the first instance that the verification role, there was no change, my lord. And the change made in the biodata also was very, very conveniently, a bracket was made, Lordship. So, the second point that I would come to, my lord, is with regard to the other case law, that is 2014 SEC Online Bombay 2243, Lordship, relied upon by my friend at paragraph 14. If I may read, my lord.
Yes.
Paragraph 14. In the instant case, the petitioner had, at the time of his entry in the service, produced school leaving certificate, Lordship. The fact that cannot be, that is not dissented to by my friend, Lordship, is that the school leaving certificate was produced without any direction a good 6 days after he joined service, Lordship. Not at the beginning, at the entry of the appellant in service, my lord. So this case will not help my friend, my lord, because it is going in favor of the state, Lordship, because this school leaving certificate was submitted on the 9th of March 1988, whereas he had joined service on 3rd of March 1988, my lord. My lord.
That's all.
My lord.
Only on law, please.
My lord, yes, my lord. With regard to the, my lord, delay part, my lord, I approach this honorable court on delay. My lord, there is no occasion arise to the appellant to know there is a true date of birth recorded, my lord. Number two is, with regard to the receiving of the service benefits, my lord, during the pendency of the writ petition, they have released the amount, GPF amount. GPF is the employee's money, my lord. Number three is, my lord, with regard to the true date of birth, my learned senior is silent on that. Who has done that, how this thing happened, silent on that part, my lord. And with regard to the fake end of service, my lord, change the color of the case, my lord. This is not a case of change of date of birth, my lord. This is a case of irregularities committed by the state respondent. This is not a case of change of date of birth at the fake end of service. And the same principle will apply to the employer also, my lord, in my judgment up to 2022, my lord. At the fake end of service of an employee, employer cannot raise that issue, my lord. The same thing, my lord, in my judgment. And with regard to the principle of natural justice, my lord, they put down a notice. On the very next month, they prematurely release me from service. During my service career, they could have issued me a notice because they are the custodian, my lord, of the records. That is my only submission, my lord.
Lordship, this point was never raised before the learned single judge.
But I raised, my lord.
No,
I
it was
raised, my
not.
lord. That is my only case, my lord.
Then again, officially, it didn't is when in the records. But the superintendent says that no, here order of the complaint authority will issue. Changing the state of birth. Initially, 64, then change the state. You can just order this, the competent authority will go into it.
Oh, it has come.
Competent authority at that point of time did not go into it and pass a result order, changing the date of birth. Tell them go into it now. Taking into account the 222 input. Chief Justice and Honorable Toros. And if they think that it was really 67 and 67 was right, then
What consent from additional AG?
that's the result of it.
Okay.
Yes, please take note. Hearing concluded, stop. CAV.
Much obliged, Lordship.
DP obliged.
Obliged.
From the daily list,
1 minute. With the stapler, you staple this and it attaches here.
from the daily list, item number 1.
May it please your Lordship.
Yes.
Lordship, on the earlier occasion, Lordship has directed us to take fresh step in this matter, Lordship.
Sorry?
Your Lordship, on the earlier occasion, Lordship has allowed us to take fresh step in this matter, Your Lordship. Lordship, we have done that, so Your Lordship, but we're still awaiting service report, Your Lordship.
All right. On the prayer of learned counsel for the appellant, this appeal and miscellaneous case is adjourned till 18th November to receive the service return report. All right? Or you want it earlier?
No, Your Lordship, it's
Huh?
much obliged, Lordship.
Item number 2.
Yes.
Lords had granted us a week's time to file a rejoinder to the affidavit filed by the respondent state, my lords. Lords, I seek a little accommodation. If your lordships kindly grant us another week's time, my lords. We've not been able to file it.
All right. On the prayer of learned counsel for the petitioner, this public interest litigation is adjourned till 11th November.
Highly obliged.
Full stop. The rejoinder may be filed by 8th November.
My lords. Obliged.
Item number 3.
Sorry, my brother will not be there. 11th, 14th will be there. Or 13th November.
30.
Item number 3.
My lords, I have filed the joint inspection report, my lord. This matter, public interest litigation, pertains to degradation of a river, my lord, which is called a Mintudu, my lord, which is a very important river in Gentile Hills, which feeds to the town of the Jowai town, and also it serves as a water source for the irrigation purpose of the agriculture. And also, my lord, it has got a very important belief in the aspect of religious belief. And my lord, now there was a construction of the road, my lord, which is called a Jowai bypass road, my lord. Now, because of the ongoing constructions, my lord, all the debris and the mugs, my lord, they have been pushed down to the hills, which slides down to the river, causing huge degradation of the water of the river, my lord. And also it has destroyed a substantial amount of agricultural land, my lord, which is a rice bowl of Gentile Hills, my lord. So accordingly, this PIL was registered, my lord. I was 3 reports. With this, I filed 3 reports, my lord. Now, if my lord have the reports which I filed yesterday, my lord, that's before my lord. The first, my lord, has it, the report. So there's an introduction, my lord, and thereafter, my lord, it contains the inspection team, my lord, pursuant to the order of this court. Then in number 3, my lord, these are previous reports, my lord, 3 previous reports that I've submitted and given some suggestions along with the photographs, how it has changed the demographic.
Would you like to deal with these reports?
Lordship, yes. Lordship, as per the order of this Honorable Court, Lordship, on 21st 10. Lordship, will just kindly have this order. They had done the inspection on 24th September, Lordship, and they had sought for a week's time to file the report. So, Lordship, we have received.
So, there are 2 previous reports.
Yes, my lord, there are 2 previous reports which I have submitted, my lord. And
Mr. Amicus, have you been granted any remuneration by the court?
no, my lord, but that is okay, my, no, not an issue.
No, we will grant you remuneration for the work. They're doing work.
I leave it to my lord. Otherwise, it's okay, my lord. It is it's an honor to.
And it is also our honor to reward you with remuneration.
My lord, I bow down, my lord.
3 reports.
3 reports are there, my lord.
Learned Amicus Curie has filed 3 reports before this court, the latest of which is entitled a joint inspection report dated 28
Yes, my lord.
October 2024. Handed up to us today. Mr. Khan, learned AAG, seeks time to file an affidavit by the state responding to the said reports.
3 weeks?
Let such affidavit be filed by
3 weeks?
3 weeks.
There is also one more. May I submit one more? I just wanted to bring to my lord's attention, my lord. There is also one road which have come to my notice, to my knowledge, my lord. Now the Shillong bypass, my lord, that is coming up with a 4-lane, my lord. Now this 4-lane is going, the alignment is going to the hills, my lord. This is and the place where they have gone for an alignment, there is a water bodies, my lord. Around 5-6 water sources are there. That is feeding to the villages, around 5-6 villages, my lord. If this diversion happens, then these 5-6 water bodies are going to be destroyed. I went personally myself to see, just to get a first information. I've written a letter as an amicus to the district magistrate Riboy. No reply has come. Just wanted to ascertain, because this concerns, my lord, not only river Mintudu, my lord, it concerns the water bodies, depleting of water bodies.
This is within the sphere of work granted to you by the court, or something.
No, it is something which I wanted to bring, because this, at the end of the day.
Please don't do it. You confine yourself to the sphere of activity granted to you by the
my lord.
Such affidavit may be filed by, is to be filed by November 19th. Full stop. In considering the nature, scope and volume of work done by the amicus curiae and the expenses involved in doing so, we direct the state to pay him an ad hoc remuneration of rupees 75,000. Also, learned AAG will ensure that all formalities are complied with by the state for making payment of this remuneration to the learned amicus curiae as expeditiously as possible.
Deeply obliged.
So list this application once again on 19 November.
My lord. Deeply obliged.
Item number 4.
May it please.
Yes.
So please. State is in appeal, my lord, with regard to resettlement of the persons on state land.
You are for the appellant.
I am for the state appellant, my lord. I am Advocate General, my lord.
Sorry?
I am Advocate General, my lord, of the state. So I am appealing for the first time as the AG before your lordship.
It's a pleasure and privilege to hear you.
Lordship, we have been engaged in some discussion to resolve this issue because this is the land on which settlement has taken place long time back. We have been negotiating, and to a great extent we have been able to resolve this issue, my lord. And
So, Mr. Advocate General, when should we keep this matter?
after 2 months, your lordship, kindly, because there are some religious structures on the place, and we are trying to work out something, and we have approached central government also, my lord. So
This
we
is
need
public interest litigation.
No, my lord, because the high power committee was constituted. High power committee was constituted to look into the resettlement issue, my lord. That was challenged by my learned friend's client, my lord, and then against that decision we are here. And in the meantime, we have resolved the matter by negotiations to a great extent, my lord. So some teething issues are there, which we are sure that we will be able to resolve. We need some time, my lord, for doing that.
Take 1 month, 2 months will be enough. Who's for the respondents?
Lord, I am appealing for the respondent, and we have also the appeal. So there are, this is a cross appeal also, Lord. We have filed appeal. They have filed appeal. We are the respondent therein.
After hearing appearing counsel, we adjourn this appeal for further hearing. On 25th November,
Grateful, my lord.
2024,
So kind.
up to item number 5.
Yes. Look, no, item 4, my lord, 5 is a separate matter, my lord.
Nice.
Item number 5.
May it please your lordship. Lord, this is a case, my lord, relating to settlement of Weighbridge, your lordship. Now, my lord,
Yes.
so for the settlement of Weighbridge is concerned, your lordships, this is, my lord, governed by a set of rules, my lord, Meghalaya Weighbridge rules. This was formulated and notified in the year 2009, your lordships. Now, my lord, as per the rules, if I can take my lord briefly to the rules, my lord, at page 56.
No, what is the issue involved?
No issue, I am just coming, your lordship. Now, my lord, as per the rules, now, my lord, the settlement was made for 3 years. And this is renewable. As per the statute, this is renewable after every 3 months. Now, my lord, settlement was made in 2017 in my favor, your lordships. Now, my lord, what happened? Before the expiry of the original term of 3 years, as required under the statute, I filed a formal application for renewal as per the rules. Now, my lord, that was pending. In the meantime, my lord, there was serious disruption, my lord, due to COVID. Now, my lord, what happened? The authorities were sitting over my renewal applications. So, in the situation, my lord, in 2021, your lordship, I filed a writ petition before this honorable court. My limited grievance was that I filed a renewal application. The government should have taken a call. So ultimately, my lord, the government filed an affidavit. My lord, this is important. The affidavit was filed by the, my lord, Commissioner and Secretary Transport and Transport Commissioner. And they made a categorical amendment that we are favorably doing it. This is under consideration, and almost, my lord, they have considered that we are doing it, we will renew it as per the rules and policy decision. So these honorable court, my lord, closed the matter relying on the, my lord, statement made by them at paragraph 5 of their affidavit.
Weighbridge
Weighbridge, your lordship.
for
Weighman, my lord.
the weight of trucks and
Yes, your lordship. Yes, yes. my lord.
and other goods carrying vehicles.
Exactly, your lordship. This is with a twin purpose, my lord. One is, my lord, to check the speeding vehicles. And secondly, my lord, this is also used, my lord, for collection of royalties. Suppose, my lord, a coal-laden trucks. Weighment is done in a weighbridge. After the volume of weight it is carrying, a slip is issued. On the basis of the volume, my lord, the royalty is collected. So, my lord, this honorable court disposed of the matter, my lord, relying on paragraph 5.
So this license is granted by which
Transport
department?
Transport Department. Now, my lord, what happened, your
For
lordship?
you to operate?
Yes. Now, my lord, what happened, your lordship? This was closed. So ultimately, my lord, it was renewed, my lord. And a fresh agreement was entered into, my lord, in the year 2020.
What do you get out of this payment?
My lord, we are required, my lord, under to pay a lease amount. So far we are concerned, my lord, we are paying, my lord, annual lease amount of 25 lakhs. Lease amount of 25 lakhs.
No, what is your source of revenue?
My lord, per vehicle, my lord, we do the payment, we are entitled to collect a fee of rupees 200. This is as per the statute and as per the agreement. So, my lord, after, my lord, adjusting all the expenditure, my lord, whatever is the profit, my lord, that comes to us. Now, what happened, your lordships? After the disposal of the case, my lord, the authorities, my lord, following due procedures, they have renewed it for 3 years, due to expire, my lord, September 25, next year. Now, my lord, when I was operating, my lord, settlement was executed. Strangely, my lord, in the first part of the year 2023, I received a letter which simply say, you are permitted to operate the weighbridge till September 23. I was shocked, my lord. The agreement was still, my lord, the renewal is still for, my lord, September 25. Now, this letter came from nowhere, and he say, my lord, that you will allow to operate only up to September 23. Now, in the situation, my lord,
From September 23, you have stopped.
no, my lord, what happened? I filed, my lord, a writ petition challenging this impugned order, which say that I was allowed to operate only up to September 23.
Yes.
Lordship, I filed a writ petition. May 20. Now, well, I filed a writ petition, my lord, challenging that order. That order was issued in May 23, my lord, challenging that order. Now, my lord, the government filed an affidavit. So, my lord, there was some hearing, my lord, that at one stage, my lord, this honorable court granted a stay in my favor. So, I went beyond that deadline set by the government, my lord, that is September 23. So, while, my lord, that interim protection was enforced, my lord, government has issued a fresh order withdrawing the impugned order, which was under challenge. So, by withdrawing the impugned order, my lord, they have restored the original lease agreement, which subsists till September 25. Now, my lord, while I was, my lord, now hopeful that I would complete the term, my lord, what happened? Within 2 days after the withdrawal, what they did, my lord, they had withdrawn the enforcement officials. Now, your lordship will appreciate one thing, my lord, I need to place it. Now, this is an integrated weighbridge, my lord. Come check it. Now, here, my lord, what happened, your lordships? My lord, the weighment is done. After weighment is done, my lord, weighment slip is issued. And on the basis of the weighment slip, my lord, the enforcement official posted there, they collect the royalties. Otherwise, my lord, in the absence of enforcement official, my lord, I would not be in a position to operate it. But strangely, what happened after withdrawal, my lord, they had also withdrawn the enforcement officials. Thereby, virtually, my lord, they have closed down my weighbridge. So, in the situation, my lord, I filed yet another writ petition, my lord. Now, my contention in the writ petition, my lord, once the impugned order was withdrawn, my license was restored. I was entitled to run it, operate it till, my lord, September 25. So, by withdrawing the enforcement official virtually, you had closed down my weighbridge. Now, my lord, this matter came up for final hearing, my lord, before the learned single judge. And the state government, they filed their affidavit in the second case also. They are categorically stand yes. Moment the impugned order was withdrawn, the first writ petition which I filed challenging the interim order became infructuous. That is their stand categorical stand in the affidavit. And that is what we also considered, my lord, submitted before the learned single judge. But the learned single judge, my lord, took up the second writ petition, my lord, where I had challenged the action of the state government, withdrawing the enforcement official, thereby making my Weighbridge inoperational, my lord. Learned single judge held the manner in which settlement was made. Number one, the person who signed the lease agreement, that is the commissioner of transport, he is not an authorized person, and that was also the stand of the government. He is not the authorized person. And that is basically, my lord, this is one thing, and another, my lord, another finding of the learned single judge, that while the 21 writ petition was disposed of, relying on a statement made by the Secretary of Transport and Commissioner of Transport, that yes, we are going to renew it favorably. My lord, these honored learned single judge have that in that judgment, we have never given a mandatory direction to do the settlement. And on these two grounds, my lord, holding that since the settlement was done, my lord, by a person who is not authorized, dismiss the writ petition, lordships. Against this, my lord, I have filed disappeal, your lordship.
Done the settlement means?
My lord.
Settlement means what? Settlement?
Settlement means, your lordships, what happened, my lords, as per the rules, any Weighbridge, either the government can manage and maintain its own Weighbridge, and it can use the private person to set up Weighbridge. If it is a private person, my lord, the first requirement is tender is to be plotted. He should have a suitable plot of land in a designated area. He should have the...
So what is settlement? Settlement, you said settlement?
Settlement, my lord, I'm talking lease, my lord. I'm referring to the lease. I'm sorry, my lord. I'm referring to the lease. Now, what the learned single judge sees, the authority who...
We have understood. Let us hear the learned advocate general.
Yes, my lord, the writ petitioner set up a case that he is having the permission to run the Weighbridge under the statutory rules from 2017 to 2020, my lord. 2017 to 2020. Statutory rules also contemplated provision of...
Is it true that you have once again renewed the lease?
No, my lord. That is my own case, that there was renewal of lease takes place under the statutory rules, my lord. And the period which is prescribed in the statutory rule is, my lord, is that 3 years initial term, and it's subject to meeting the certain terms and conditions of these rules, you will get another 3 years. Now, his lease was of 2017. At best, he could have got up to 2023, my lord. That is first submission. And second, my lord, is that the lease is renewed only by the approval of Secretary of the government, my lord. Statutory rules contemplate that Transport Commissioner will forward it to the government of Meghalaya. Secretary will approve, and that approval has never been granted. Commissioner Transport entered into an independent lease on his own, and contrary to the statutory rules, my lord. That is one submission, my lord. Second submission, my lord, is that his prayer in the writ petitions were threefold. First prayer was that there is a...
Lease and license was granted together.
Lease and license was granted together.
In 2017.
17. The precise date is, my lord, 7/12/2017. Your lordship has observed that we should file a brief written submissions. We should come with that. 17/12/2017.
For 3 years.
3 years, my lord.
Then again renewed for 3 years.
Renewal is also renewal is also subject to certain terms and conditions of the statutory rules.
So it was renewed.
It was not renewed, my lord.
Okay.
My case is that it was never renewed by the government, my lord.
Then it came to an end in 2020.
It came to an end in 2020. There is no agreement extending the lease from 2020, but ad hoc orders were passed time to time, under which the appellant was running the Weighbridge, my lord.
Yes.
the appellant filed a writ petition before this honorable court.
Yes, that you have said.
Yes, and in that writ petition, he said that his renewal should be considered. The learned single judge disposed of the writ petition, observing that consider it. That consideration has never taken place before the government. Transport Commissioner quoting the order of learned single judge that there is a direction to renew it. And based on that direction, he on his own renewed the lease agreement in 2022, my lord. On 1st June 2022. 1st June 2022.
Renewed till 25.
For 25, without relying on the order of learned single judge to the extent that there is a direction by learned single judge to renew it. Learned single judge called for record, found that there was no direction by learned single judge to renew it, and the commissioner has acted illegally in renewing the lease agreement. Learned single judge also returned the finding that Commissioner Transport was not competent under the statutory rules to renew the lease. Your Lordship has observed in the last order that brief written notes, so I have prepared with list of brief.
1625, and then this was revoked.
This was not then government by 20th June 2023 informed the Commissioner Transport that this lease, this renewal, the appellant is allowed to operate the Weighbridge up to 30th September 23 only, my lord. 30th September 23. Appellant filed a writ petition, my lord, before this honorable court. In the writ petition, he made 4 prayers, my lord. First prayer was that the government was running its own departmental weighbridge, and that weighbridge should be closed. That is the first prayer, my lord.
No, on 26-23, the government.
Yes, government wrote to the Commissioner of Transport that the extension to run the weighbridge is up to 30th September 2023 only. 30th September 2023 only, my lord.
This ad hoc extension.
Ad hoc extension. This order was never challenged, my lord. This order was never challenged. This order was never put to test by the appellant, my lord. On 1st August 2023 also, my lord, because every quarter the lease premium was being paid by the appellant, and that challan was also returned by the Commissioner of Transport on 1st August 2023, saying that there is no extension of the lease agreement, and therefore we are returning the challan, my lord. I have prepared a short written submission, my lord.
Yes.
And which contains the dates and finding everything with a copy to friend. And your lordship has observed both the parties should bring the. So
I have submitted.
I have not received the copy.
So the first writ was also disposed of on a misconception.
Same set of facts. And if your lordship would see the prayer at page, because prayer was. First prayer was that government should not run a departmental weighbridge. Second prayer was that the staff which has been appointed or deputed on the weighbridge should be posted in his weighbridge, my lord. Your lordship may kindly see page 184 of the writ appeal.
There is more or less your submission. You wish to continue?
It will take some time, my lord, so we can have after some time also, my lord.
Tomorrow?
Tomorrow. It will do.
How much time you likely to take?
It will take about half an hour, my lord, for my side.
Well, I'll take little, say, another, my lord. I'll try to conclude it within 35 minutes.
Because subject to what my learned brother thinks, if the first writ has been disposed of on a misconception that your lease has been renewed, so it is disposed of, in spite of the issue being pending before the court that whether you are entitled to renewal or not. Now, on the basis of that, you proceeded with the second writ?
No, my lord. It's not.
No. You proceeded on the basis that the government assured you or expressed a decision or expressed a decision having been made in court, expressed in court a decision having been taken by them to renew the lease. So renew the lease means lease, license, everything springs back to its original position. So on that basis the writ was disposed of or withdrawn by you. Now if that is not the position, then that writ has to be revived by us. And that writ and the second writ will follow, might or might not follow, depending on the result of the first writ. They have to be clubbed together and heard by the single judge.
My lord, only thing I'll just point out, some, I think, regarding the facts, my lord, there's maybe some confusion, your lordship. 21, the writ petition filed, my lord, with respect to renewal. My prayer is my renewal application is pending. Please renew it. Now, state government, my lord, I'll annex the affidavit. They came and they make a categorical statement, averment, that we are doing it favorably. We'll do it. Renewal. Now, this honorable learned single judge, taking note of paragraph 5 of that affidavit, dispose of the matter. Now, thereafter, what happened, my lord? The authorities concerned, my lord, following the procedure, they have renewed it and they have entered into a fresh lease agreement, which subsisted, my lord, till September 25. In spite of the renewal, my lord, thereafter they have issued this impugned order, which was subsequently challenged.
Which they say the commissioner had no power.
Well, I'll show. That is absolutely wrong. I'll show, my lord.
So your first writ effectively must revive on the basis of the submissions made today.
Yes, my lord.
My lord. This first writ petition, they themselves, my lord, there were 3 writ petitions I am referring to. One in 21, which was disposed of, my lord, which has nothing. Now, then I have filed in 23, my lord, a writ petition, your lordships, challenging the order by which the term of my license has been truncated from 25 to 23, your lordships. That was under challenge.
Now we have to see the terms of that order on what
on
what terms that writ was disposed of.
Yes, yes, lordship.
Now if we do not know if the order of the court or the judgment of the court is that there is an assurance by the government to renew the lease. Now that will
I'll place, my lord. I'll place that, my lord. I'll place. All these documents are here.
That will have a different effect, Mr. Abhi.
Yes, my lord. There is no, even learned single judge in the impugned order has
an undertaking kind of a thing is
no undertaking. And learned single judge in the impugned order has said that there was no such direction also, in the impugned order also. Learned single judge has interpreted his own order in the impugned order. I will place that for you.
Let it come, my lord, tomorrow.
Tomorrow. After having heard learned counsel for the parties at some length, we direct that the appeal be fixed for further hearing tomorrow as the first matter in the list.
Item number 6.
I appear for the respondent.
Yes.
My lord, I have a request as a respondent.
Yes.
I am being led by Senior Counsel Mr. N. Venkatraman, who is also the Additional Solicitor General, but he's appearing in his personal capacity. He has a personal difficulty today. I am sincerely requesting, and I apologize for, I understand the court stand is specialist, but I'm requesting for an adjournment.
Mr. Venkatraman?
Yes, my lord.
Yes.
He is the Learned Attorney General.
Yes, additional solicitor. But he's appearing for private party in personal capacity, my lord. Reliance
In his personal capacity.
But who's the Attorney General?
His name is Venkatramani is the Attorney General.
Mr. R. Venkatramani is the Attorney General.
Yes.
Yeah.
So when do you want the matter to be taken up?
I am requesting, if it's possible, my lord, around the 29th of November at a fixed time. This is a very interesting question on insolvency law and the ability of a state government to seek claims and payments post the resolution of an insolvent company.
We can have both the matters on Tuesday. You might be here physically.
29th.
Yes, my lords.
That's a Friday.
It's a Friday, so I'm requesting a fixed time if your lords would be agreeable.
No, but
Subject,
will
of course, to the convenience.
the learned additional solicitor general appear in person, physically?
We will try to appear in person, otherwise online, but we will aim to appear in person. I'm being told that
Yes.
if we have a fixed time,
Please request him to appear physically.
I'm grateful.
How much time the matter is taking? What is the stake involved?
Your Lordship, stakes are high because it is relating
About
to.
3 crores is the stakes.
But the issue has got wider ramification for the
Award, arbitration award.
No, it is with regard to the winding up order. The IRP was interim registered professional was appointed under IBC code, Insolvency and Bankruptcy Code, my lord. And statutory dues have not been waived. Our case is that statutory dues have not been waived. And on that issue, we have to place 3-4 judgments of the Honorable Supreme Court. My learned friend has also cited 3-4 judgments, my lord. This matter may
If I may just explain the question, my lords, just to differ with the learned AG. My lords, we are a company that came out of insolvency in 2022 December. Post our resolution of insolvency, the appellant raised demand notices for dues prior to insolvency. We submitted that under the provisions of the Insolvency Code, as this Honorable Court is well aware, that we take over on a clean slate and all dues, whether statutory dues or otherwise, stand permanently extinguished under Section 31. We cited judgments of the Honorable Supreme Court and the learned single judge agreed with us. Though, of course, the appeal has been filed on the ground that the Supreme Court judgment in Rainbow Papers applies to them and certain other grounds. We still think that this matter may not take more than 1 hour each side, but I'll refer to the learned AG on this one.
All right. We will keep it on 28th and 29th so that the matter can be finished.
Yes, my lord.
Very grateful, Your Honor.
Grateful.
List this appeal for hearing on 28th and 29th November 2024. And 29th.
Very grateful, my lords.